can tell you what I expect the evidence to show. And what I expect the evidence to show in this case is that YSL, the group made up of the defendants sitting before you today, along with other both indicted and unindicted co-conspirators, YSL operated as a pack. The quote that I read to you earlier is from one of my favorite books as a kid, The Jungle Book. In case anybody recognized it, those were Rudyard Kipling's words and not mine. But they are appropriate for where we are today. For 10 years and counting, the group calling itself Young Slime Life dominated the Cleveland Avenue community of Fulton County. They created a crater in the middle of Fulton County's Cleveland Avenue community that sucked in the youth, the innocence, and even the lives of some of its youngest members. Now, the evidence is going to show that this group started out as a group called Rock Crew. And Rock Crew stands for Raised on Cleveland. The evidence is going to show you that Rock Crew, in fact, is a criminal street gang. It's not the kind y'all are used to. If you're more familiar with the national gangs, such as the Bloods and the Crips that operate in LA or in Chicago. But make no mistake about it, Rock Crew is and was a gang. It consisted of 3 or more members with common identifiers, signs, colors, linguistic choices that committed crimes on behalf of and in furtherance of Rock Crew itself. That particular organization aligned itself under an umbrella of a larger, more traditional street gang called Sex, Money, Murder, Bloods. They adopted the nomenclature. They would do things like replace C's in words with the letter B, because traditionally Crips and Bloods were not aligned with one another. So Cleveland Avenue became Cleveland. Some of you may have indicated during the voir dire you've heard or are familiar with the Cleveland Avenue area. Maybe you've even heard of Cleveland Avenue Day. The evidence will show that this is where that comes from. The evidence will also show that sometime in 2012 or thereabouts, an internal rift or divide occurred among the members of Rock Crew. Now, the defendant, Jeffery Williams, seated back there yawning right now, he was an original member of Rock Crew. And the kind of crimes that Rock Crew did consisted of smash and grab burglaries, stealing ATM machines, things of that nature. When Rock Crew split up, YSL, or Young Slime Life, was formed. And the defendant, Jeffery Williams, was its proclaimed leader. Young Slime Life came about and consisted of 3 or more people when it began. 3 or more people who were willing to and who did commit criminal street gang activity, that is crimes, that were intended to further the purposes and advance the directives of YSL itself. Now, there will be no evidence of a written contract or anything like that. You won't see bylaws of YSL, because this was a group of people associated in fact, who used common identifiers common names, common colors, common symbols, to communicate with one another and to express themselves to the rest of the world. So YSL, as the evidence will show, they didn't move individually. The members and associates of YSL, they moved like a pack, with the defendant Jeffery Williams as its head. You'll hear from witnesses, both law enforcement and lay witnesses, who personally experienced and who personally witnessed the activities, the crimes that were committed. You'll hear from law enforcement officers like Kimberly Underwood and Tyrone Dennis, whose main goal wasn't to go out in the streets and lock up people who looked like them. It was actually to touch souls in the streets, to touch young people, and to alert them of the dangers and the drawbacks of becoming a part of and becoming involved in gangs like YSL and Rock Crew. You'll hear about conversations with educators. You'll hear from members and associates of the gang itself. Now, as to how those members and associates will respond or act once they're actually in court and on the stand, that's something that I am truthfully not able to predict to you fully. But the court has given you instructions on determining and judging the credibility of the witnesses. And I trust that all of you will in fact follow those instructions. The evidence will show that YSL checks all of the boxes for being a criminal street gang. As I stated earlier, they are 3 or more people associated in fact. Their members commit crimes on behalf of the gang. They commit crimes such as armed robbery, hijacking, motor vehicle theft, theft by receiving, stolen firearms, so many stolen firearms, possession of a machine gun, and narcotic sales. And last but certainly not least, murder. What you will not hear any evidence of is that the defendants were not involved in a criminal street gang. You will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now, this is
Let me object to that statement, please, as burden shifting.
Object basis?
Burden shifting, and under Parker versus the state at 277.
Why don't we take that up then?
39.
I'll note your objection. I'm sustaining the objection. Why don't you rephrase, madam?
yes, Your Honor.
Just rephrase it. Ladies and gentlemen, I'm going to explain to you at the appropriate time, ladies and gentlemen, what the burden is in this case. Remember what I told you earlier, that the burden never shifts to the defendants to prove for certain innocence, they're presumed innocent. And it's only until you hear evidence that you decide is sufficient, and I'll instruct you on how you're supposed to do that at a later point in time, okay? All right.
The evidence will show that YSL did not adhere and does not adhere to all of the customs of a traditional street gang. And the fact that YSL does not mirror all the customs of a criminal street gang, the evidence will show makes it no less a criminal street gang. The defendants on trial here today have, through their actions, displayed not only their allegiance, their alliance with one another and with the gang itself. Through their actions, they have displayed an unspoken agreement to participate in that game through a pattern of illegal activities. And again, the head of this gang is seated in this courtroom too. The last paragraph of that poem that I read or spoke to you earlier goes as follows. Because of his age and his cunning, because of his right.
This is argument. This is not
What's your objection, Mr. Harvey?
that it's argument.
Okay, Mr. Harvey, hold on. Madam, it is argument at this point in time, so I'll sustain the objection, okay?
Yes, Your Honor.
All right.
The evidence will show that these defendants, that the members and associates of YSL, they knew who their leader was, and they knew the repercussions of not obeying their leader. You will hear evidence that when members and associates of YSL got in trouble, got locked up, the first person they called was either this defendant or one of his family members. Now, they didn't call him directly because he knew and they knew that he needed to have distance between himself and the crimes members and associates of YSL were committing on behalf of the gang. So they would reach out to his sister and have his sister reach out to somebody else and eventually get back to King Slime, as they called him. You will hear evidence that members of YSL committed armed robberies. You'll hear evidence that to slime someone is to do them dirty, and that sometimes members of YSL committed crimes against other family members of their fellow gang members. You'll hear evidence that when one of the associates or members of YSL did something to what Jeffery Williams had perhaps considered a friend, they were threatened with their very life. Tell them to get that stuff back or they will be killed. You'll hear evidence that YSL, they had opposition within the city of Atlanta and Fulton County. That there were other gangs that were at various points in time at odds and even at war with YSL. One of those gangs was known as the IF gang, IF, Inglewood Family. You will hear experts come in here and tell you more about how the Inglewood family bloods in any way made its way down to Fulton County. You will also hear evidence about how one of the members, one of the beloved, of whom YSL considered an opposition group, was gunned down. Donovan Thomas on January the 1st, 2015. January the 10th, my apologies, 2015. Gunned down, openly and notoriously. Because the evidence will show that part of the reasons that criminal street gangs operate the way that they do is to establish dominance and to establish control and to establish fear. You're going to hear that this gang stole at least 3 lives from this community over the last 10 years. At least 3 that are referenced in this indictment. You'll find that as a result of this gang's activities, a young woman who had nothing to do with either YSL or any of their opposition was gunned down by people trying to get back at YSL for what they did. You'll hear evidence that after the murder of Donovan Thomas, no less than 50 shootings occurred over the course of the next several months. You'll hear evidence that hundreds of bullets were fired into cars, into homes, and into people as a result of the rift young Limelight had with other people in the community. So what are they accused of, and what are you here for today? The judge read the 4-hour-long indictment to you 12 months ago. He didn't read it to you again today, but he generally gave you what each defendant is being charged with and what the state has the burden of proving beyond a reasonable doubt as it relates to each defendant. But just to broadly touch on those, the crimes that the state has proven to you over the next several weeks include conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act. That is an absolute mouthful. So we'll just say Rico. There's no substantive allegation of Rico violations here. And by that I mean there's a difference. Here the state is alleging that these defendants, they had an agreement, unspoken, but no less an agreement to obtain property, things of value, cell phones, cars, stolen guns, through a pattern of illegal activity. The evidence will show that it's sort of like if two people said, okay, you know what, we're gonna go toilet paper our dean of admissions house. And they sat there thinking and talking about it, and someone overheard them and reported them to the police. And the police came and said, okay, I'm gonna arrest you all for conspiracy, for planning to go and do this. The evidence will show that it's not enough that they were planning to do it. Somebody has to do at least one thing in order for those two people to be found guilty of conspiracy. So say one of you goes and says, let me go get the toilet paper now. Then y'all are in trouble. That's what we have here, and that's what the evidence is going to show. There was an agreement among the members of YSL to obtain property and things of value through a pattern of illegal activity. And it is their actions over the course of the last 10 years. It did not stop, by the way, in 2015. It didn't stop at all. It continued up through and even into 2023, after this case was indicted, as the evidence will show. But their actions are what the state will be looking to you to evaluate and determine. Does this action show that they are agreeing to participate in this organization, this enterprise, through racketeering activity? You'll see evidence, as I stated, of not just drug sales, trap houses, drug houses, whole houses out of which drug sales were conducted, where they held long-arm guns by the door, where they stood ready to act on command if either one of their number called. Who's on trial before you today is Rodelius Ryan, Lamarcus Nichols, Marquavius Huey, Jeffrey Williams, Shannon Stillwell, Diamante Kendrick, and their actions during the dates that are listed in this indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor.
It-
You have an objection?
Yes, sir.
Basis.
For motion.
All right. Ladies and gentlemen, this is one of our breaks. I'm going to need to probably ask you to retire to your headquarters jury deliberation room, and we'll call you back in just a minute, okay, when we finish up our business, all right? Remember the court's admonitions, ladies and gentlemen. All right, please be seated. Our jury has left us. All right, Mr. Steele, what's your motion, sir?
Good morning again, Your Honor. Your Honor, last week, 2 weeks, 3 weeks ago, you ordered the parties to share all of their displays in opening statement to the others so we don't have to have these interruptions. I did that. The state shared with me 4 attachments. That's all they had. That's what I got. What you just saw on your screen, if you don't remember, I'll ask the state to put it up and I asked for it to be marked as exhibit, is what you already excluded. It states that Mr. Ryan was convicted of murder and I represent the co-defendant who's not on trial on the appeal. How did that not get sent to me so I could bring it to this honorable court's attention? 1. And 2, how do we just violate court orders? So yes, I have a serious motion for a mistrial because it's intentional misconduct. That's my motion.
All right.
And I'd like the screenshot to be captured for Mr. Weaver to put in the record.
I'll admit it is next court exhibit in order of the state's presentation anyway, so. All right, so that'll be court 1 for purposes of the trial. So, Ms. Love, what's your response to Mr. Steele's assertion about Mr. Ryan?
As it relates to Mr. Ryan and the exhibits that the state intended to play and to display for the jury, I sent to Mr. Steele and everyone else the pictures and the photographs that I expected to use. As it relates to the slide to which Mr. Steele is now referring regarding his representation on appeal, I'm not certain if the objection goes to the fact that there was the conviction, because that's part of the indictment and that's part of the evidence that the state expects will show, or if it's as to his objection about the fact that he represents Mr. Ryan or Mr. Blaylock on appeal.
Don't represent Mr. Ryan.
Mr. Blaylock, then.
Excuse me. I would never said this, ever. That's it.
So what's your objection based upon, Mr. Steele?
Objection based upon, I argued this before this honorable court. You argued the prosecution that before they ever mentioned my name, you granted this motion.
That I did.
You brought him up to this honorable court, outside the presence of everybody. We're an opening statement. I am lied to. I am saying that. I am lied to. Or if anyone else got that exhibit, I did not get that exhibit. And I've seen everyone say shaking no. And now it goes against the court's order. We are bound, duty bound to follow some of the court's order.
Going to join in the objection on behalf of Mr. Steele.
Let me see
I can put it back up,
Yes,
Judge.
ma'am.
And Your Honor, while I am putting that back up, I will state in my place that initially when there was the objection from Mr. Steele, I didn't have a clue what it was about because I didn't mention his name and didn't intend to mention his name. As I looked at the screen, I saw that part of his name was on the screen for the most part.
But I mentioned that, I ruled upon that last week. I did. That we were not, I would take it as it came in this case. And if the evidence got to that point, then I would deal with it accordingly.
Yes, Your Honor.
So,
And Your Honor, as to Mr. Steele's motion, as I'm pulling this up, the state would vehemently object to a mistrial and ask for a curative instruction and a reminder to the court, to the jury, that nothing that the lawyers say is evidence in this case. This is not at all the type of thing that rises to the level of mandating a mistrial. Certainly not. It just isn't. I have
all right.
the slide.
Pull up,
I have it now.
now,
I'm
court
about to
action,
share
court
this.
one for purposes of the motion for mistrial. All right. Okay, on slide 11 of 65, that I see where you have that at the bottom, represented by Brian Steele. So we can leave that for the time being. Leave it for the time being because it is what it was up. I'm going to deny the motion for mistrial, Mr. Steele, but I will go ahead and give a curative instruction to our jurors at this point in time. So,
Your Honor, I'm supposed to ask for a re-occurrence for my mistrial before the next process goes on. I'd like you to do me a courtesy, if you would, and allow me to do that now and preserve the motion for mistrial.
you made your motion for mistrial, and the basis, and I'm going to mark the whole state's presentation as is as court one for the purpose of your motion, and it'll go in as stated.
And I have two other issues I'd like the court to just take up. One is just remember, I know you ruled on it, but the state said earlier today that Mr. Williams is contacted through parties that they don't know to pay for other people's lawyers. So I think that couples with that exhibit. And number two, I'd like the court to now order prosecution to give me and anyone else who wants to see it. I need to see respectfully what you ordered last week, all of the displays of the state of Georgia that they have not given to us. So that's
What do you mean by what displays are you talking about, Mr. Steele?
I never saw that. I never saw the wolf. I never saw the indictment. You ordered I gave all my displays. I gave everything to the state. I got from the state.
Are you talking about using for opening statements, sir?
Of course.
Okay.
Should have been done.
All right, Ms. Love.
Yeah.
Wait.
Thank you, Your Honor. Two matters, Your Honor. One, the first thing that Mr. Steele has requested of the court regarding the representation that the state made about other YSL members contacting Jeffery Williams for representation is absolutely and has always been a part of what the state expects will show at trial.
I'm going to deny that portion, but to Mr. Steele's point, I'd already made that issue in terms of his particular involvement, and anything you need to let me know prior to that, and I need to rule upon it, and also subject to foundation. just like this. So I assume that what you told our jurors is what you expect the evidence to show? Yes?
Yes,
All right,
definitely.
so I'm gonna overrule that part of his objection. What about the last thing you mentioned?
And Your Honor, as to the court's directive that we turn over anything or any exhibits or photographs, that was my understanding of the court's directive, that we expect to show an opening statement. As a matter of course, I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele, at least part of his name on
I
here.
got that, but he's talking about, is there anything else you're gonna use in open you haven't shown to defense counsel?
I
He's
don't
telling
mind
us,
sharing.
well, I said that. I told you to do that a week ago.
Your Honor,
Because here's what I told you was gonna happen. I've got a jury that's out right now that's being interrupted. And Ms. D. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this. Because this is stuff we could take care of before our jury comes in. And that makes you all, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen. So have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
can you do that over the next 5 minutes?
I sure can.
Deputy Ingram, can you find out if our jurors are ready? Are they ready? Are they still using the restroom?
I'll send that to them right now as we're waiting.
Your Honor, we have a few. Your Honor, Jay Apt on behalf of Mr. Kendrick, can we have 5 or 10 minutes to review whatever Ms. Love is going to send us?
You can take a comfort break and I'll come back at 10 of 12. And like I said, whatever we don't finish before 12:15, we'll pick up after lunch, okay?
Thank you, Your Honor.
Who's talking?
Max Sharp.
Yes, Mr. Sharp.
On behalf of Mr. Stillwell. We've been operating pretrial with the Harvey rule. I want to make sure that the record is clear that we join Mr. Steele in his motion for mistrial. And if Your Honor.
I'll apply the Harvey rule unless you tell me otherwise. Okay?
And that will apply throughout trial.
Yes.
Okay, thank you.
Unless you tell me otherwise. Okay? All right.
Thank you.
All right, we're going to be in recess about 10 minutes, all right?
Your Honor, what I'm going to do before stating is I'm going to actually do a search for the first 4 letters of Mr. Steele's name and make sure that I didn't need anything else in there. So before I do that, I'm going to send that. I'll make that search.
All right, I have me on mute. 23. Hi, my sweets. I miss you. So this is gonna, in my opinion, gonna be a good trial. It's gonna be. My sweets, I miss oh my God. Something is going on with my Uh-oh. Somebody's fighting in the hallway here. Okay. For some reason, I'm typing in my StreamYard, and it's not showing what I'm typing to you. However, Karen, oh my gosh. Oh my gosh. I know, I'm a dork. I miss you. Your kids came home? Oh. Are you guys on my main channel? Not Conversations with the Killer, the other one? Karen, where have you been? I have missed you. So anyways, this trial is going to be good. Did you see already the drama? And I like Young Thug's attorney. He's entertaining. Right. Okay, okay. Hopefully you guys are on my main channel. Hold on, you guys. All right. Yes, main channel. Why isn't comments showing up in StreamYard? Let me see. My comments. Finally, I see yours. However, my comments are not in StreamYard. Okay. I miss you too. I am so confused about Twitter. I've given up. Did you notice that? However, I'm doing good on TikTok. I got it going on TikTok. But I like doing my lives over here so families have a voice, a safe place panel. You know what I mean? I'm having trouble keeping up with all the crime in my stuff. Want you to know I check on what you're. I know you are. You could go away, for months, and when you come back, we are right where we belong. You know what I mean? Just like I said right now, I miss you, and I know you check in on me. And when I do go to Twitter, I do check on you too. I'm like, oh, there she is. Yes, I like it. That's great about TikTok. I can't seem to keep it in my phone right now. What do I want to say about TikTok? What I notice is people don't like the longer videos. However, they are entertained about how I do my, how I do my videos, how I tell a story with pictures. I'm the only one on TikTok that does that I've seen anyways. Yeah. Yes, you've been supporting me forever. Remember, since that little baby in was it Philadelphia or Pennsylvania? And let me tell you, Miss Jackson, I have known you 5 years. Let's see, 18. 5 years. It's going to be 6 years. Wow. Do you know anything about this case? Anybody? My phone is overloaded. TikTok takes up. Yes, it does. Yeah, but you're really good at Twitter. I don't know how you do it. Because all of a sudden, okay, you know how you want to hashtag to a friend or whatever? All of a sudden, it won't let me do that. Ain't that weird? So I'm like, forget it. Every once in a while, I'll put something there. But that's it. And I'm trying to get my other channel going, the Conversations with a Killer. However, nobody is subbing up to it. I don't know why, because it's going to be very, very entertaining. Okay? Just like me. Well, I think I am. And I thought I had enough hours, and I don't. Because remember, I told you guys that channel for sure will be monetized because it has nothing to do with victims. It has to do with me talking to the convicted. Yep. Hold on, I'm trying to get my so if you guys want to share that, that would be so awesome. Because I'm not sharing nothing. So nobody can steal my shit and take advantage of me. So everything's going to be copyrighted. Sure is. That's right. That dear little baby. I know. I cried. Do you remember that? I got all choked up trying to do that video. Hey, Green Goblin, how are you? What does that mean? Karen is here. Bye. What the F does that mean? Are you mad at her? I've heard others can't take. Yeah. Ain't that weird? Well, I guess Green Goblin knows you, but I want to know if there's a problem here. Because Karen don't bother nobody. Who knows, huh? I don't know. Green Goblin, are you nice? Are you a troll? Are you a nice troll? So, I'm going to be doing another live later. Okay, I'm announcing it now. I got to get it ready. There's somebody in the community that did some bad stuff, okay? Because we got to bring awareness to people that hurt kids or hurt women, okay? Any kind of abuse. This is all facts, what happened. I know you respect everybody. Dang right you do. I don't know. Greek Goblin, are you still here? Okay, and then there's another thing I want to tackle because people are making true crime, which is embarrassing to me, look bad. And it's so disgusting that people are getting people's real names, their addresses, phone numbers, and showing up in their neighborhood, intimidating people. Nope. I'm gonna bring that up too. I've seen Green. Oh, have you? I haven't. Green Goblin, are you here? I will find out right now. Hold on. I'm gonna find out. Hold on, you guys. Hold on, my good peoples. Man, do I got a headache. Oh, echo. Hold on. So sub up to my other channel, please. Green Goblin, you're still here. I see ya. I'm going to show the people. I just want to know what's wrong. Oh, isn't that funny? All right. Hold on. Okay. Okay, Karen, don't let anybody disrespect you. Okay? It's a troll. But I do ask people to be respectful. Yes. So do not let that goblin disrespect you at all. So how has everybody been? I had a hard time on Thanksgiving. It was tough. I was by myself. However, My daughter says she's seen my comment when I was talking to people that day because I was by myself. And she goes, well, you could be up here with your family. And I didn't mean it like that. You know what I mean? I was just up there. Gas is crazy. Because it's like a 3-hour drive, you guys. It's exhausting. But it's worth it, you know, once I get up there. They keep me too damn busy, though. And I actually spent some time with my youngest son. The one that everybody thinks is cute. Everybody. I was posting in chat earlier and green. Okay. Oh, no. We can't have that here. Nope. Not at all. Hold on. I want to show you guys something. Nope. Why do people got to be like that? I don't get it. See? Goblin's still here. Okay. See? Goblin's still here, you guys. All right. Hold on. There's the channel. Goblin, I liked your name. But you can't disrespect anybody. Okay? All right. Because my channel is a safe place. Yeah. Really. Yeah. My surgery did not help. It is so sad. I'm going back. They wanted to put a bone stimulator in my spinal cord. And when I got there today to do the trial thing, I said, I don't know if I want to do this. I don't want no one to open me up again. That was horrible, that surgery. Hey, who cares? What do you mean, who cares, Green Goblin? What's going on with you? Are you good troll or bad troll? I am on a phone. Goblin. What did you do? What did you do? Yep, we have that here. Nope. That ain't nice. Goblin, you know what I'm going to do? I'm going to come hunt you down. No, I'm not. I'm just kidding. Oh, no.
Included our sharing exercise. I told you all to go ahead and talk with each other through when we broke.
I did share it, Your Honor.
Fine.
If I may, Your Honor.
Yes, ma'am.
Regarding the court's earlier concern brought to the court's attention by Mr. Williams, Ms. Hilton shared with me what was said on the bench. But as it relates to Cordelius Ryan's post after the murder of Shamel Drinks, that was provided from day one in discovery, Your Honor. And it is not a crime that he is alleged to have committed. We may have put that on a list, including things, but Your Honor, that is not an intrinsic act in the sense of it being a crime or criminal act. And it is what the evidence is going to show happened. What I have in the PowerPoint, I can show the court if you like. I sent that to defense counsel prior to today. I think I sent it Friday before 5. But what I have said is that on the day that Chanel Drinks was, I'm sorry, Jamari Holmes, my apologies to the court and to the family members here. What I said was that on the date that Mr. Holmes was gunned down, 12 hours after that murder, Mr. Ryan posted on his Instagram account, I bet YSL makes the news. And what I endeavored to say to the jury, that the evidence will show is just that they were advertising and representing and boasting on behalf of the gang itself immediately after the murder occurred. And these are elements that the court, I believe, will hear from detectives and evidence. These are things that the courts have said jurors and the courts should look to in determining whether something was done in furtherance of a gang. And so I would ask the court, I didn't take it out of the court instructed. I would ask that the court allow you to make reference to it. And thank you, Your Honor, for your time.
Mr. Williams? Oh, sit down, Mr. App. You can, just wait a minute. All right, Mr. Williams. What's your response, madam?
That the court already ruled on that, saying that you would bring it up as it comes forth. You stated that they couldn't use it in the opening, and I would just ask that the court use their instruction and make the state follow the instruction that the court already gave.
Okay, but it may not be what I think that Ms. Love is saying, Mr. Williams, is that the evidence may not necessarily be intrinsic. It might be for another purpose. It's what they expect the evidence to show. So, but here's the issue that kind of I'm disappointed as the court. You all could, we've had months and months and months. We could have taken this up before. I could have made it very clear. I don't need to take it up right on the eve of our jury sitting in the box. That's what I'm kind of more annoyed with than anything else. If you had clarity or wanted to seek clarity on that, I'm more than happy to rule on it, but I needed to go ahead and have some ability to do so. So I don't think it's intrinsic. It may be for other purposes, and I'll let the state reference that if they have a good faith basis to, that if they believe that's what the evidence will show. Okay?
They put it in their motion as,
Say again, madam, I'm sorry.
they put it in their motion as intrinsic evidence though. So they shouldn't have put it in their motion if they were getting.
Yes, ma'am, I would probably agree with you, but
So they
did I ever rule on that issue?
You said that you would do it later as it came.
Okay, well, here's the thing. Later is now. I got a jury in the box, so you could have asked me that an hour. I mean, we had time this morning. I could have gone through that this morning and made clarity on it for both sides. But do you have any other basis for the ruling? I mean, for my ruling, madam, any other argument?
No, just I wish that the court would just follow their own instruction.
Well, I'll follow my instructions when you all bring to my attention what you need to in a timely manner, okay? And give me the full breadth of, so I can rule upon it accordingly. That's what I'd like you all to do.
Well, they also have slide 45. They have my client's name on there as gunning down a 23-year-old, Shymel Drinks. And my client has nothing to do with that.
That was another area I'm correcting.
But they didn't get that
Ms.
slide
Love says
presentation
Ms.
earlier.
Love says she is going to remedy that and exclude it.
Thank you, Your Honor.
Okay, all right. Now, Mr. App, what is it you want to tell me?
I am so sorry, Your Honor. But thank you for allowing me to speak. I do have an objection, Judge. So, Ms.
What's your objection specifically, sir?
attempted to email us during the break the PowerPoint slides that she is using in opening. I could not open the attachment. I brought that to the attention of her co-counsels and staff, and Mr. Matthews was able to open it, and I looked over his shoulder and was able to see some of it. There are at least a dozen more slides that were never turned over to us, even though the court instructed us to share it with the state and for the state to share with us prior to opening any exhibits for opening argument. And so, I mean, these are all new to us, and I would just ask that the ones that she did not share, she shared 4, that the ones that she did not share be excluded. I'm objecting because the court ordered for us to share these. She did not. Clearly, she did it intentionally. There's also apparently factual errors in them. I would ask that any slides that haven't already been shown to the jury and that she did not disclose be excluded from her opening argument.
Yes, ma'am, and then I'll go on to the next person.
Thank you, Judge.
Yes.
Your Honor, I did not send only 4 slides or attachments. I sent to counsel for the defendants the photographs, the evidence that I intended to put into the opening PowerPoint. As far as the state's theory of the case and theme of the case and the words that I wrote, those are things that were being developed, ongoing, and I did not understand the court's directive to me that we needed to turn over the words we would be speaking. As far as these photographs go, Judge, I said to them, if they can, actually, I sent them to them. So there are some, I have only about.
Your Honor, they're a dump over.
Hold on, wait, let her finish, and then I'll let you respond, Mr. Adams.
So all of these slides that involve Christian Ebinger, I sent to them. And other than the slides involving Christian Ebinger, there is a slide of the vehicle that Donovan Thomas drove on the day he was gunned down. It's the back of the vehicle with the placards of showing the bullet defects. That will be shown. There's no one that has made any objection to that evidence being introduced at trial. Nothing that I have put in the PowerPoint includes anything that has been objected to as being admissible at trial. And I believe that, I'm not certain if this app thinks that we only serve 4. Maybe, I don't know if he had trouble opening it up, but we served, I think all of them, if not the great majority of them, because I don't have that many. I don't even have 20 photographs in this PowerPoint. So everything, and I can show the court, I will share it, I did not, with the court as well, but these photographs, I have a picture of Donovan Thomas in life. I have a picture of the barbershop where he was gunned down. I have a picture of the back of Donovan Thomas's Tahoe. I have a picture of Donovan Thomas's headshot. At the time of the autopsy, no cutting, no nothing, just his face with the number. I have a picture of, as I stated earlier, Your Honor, the truck with the defects noted. And then I have pictures of Christian Ebinger, all of which were provided, and that's the extent of it. The majority of the slides have my words, my work product on them.
All right, Mr. Adams, before I go ahead and respond.
Your Honor, no one's suggesting that she had to turn over the text of her opening argument, but if she's going to show a PowerPoint to the jury, that is what the court instructed us to share. We're visual exhibits, and that's what she's doing. She's placing it up on a screen for the jury to see. And whether that's her own words as part of her opening as a PowerPoint, or it's just demonstrative, she could have shared it, and she didn't. And she did it. And she's suggesting now to the court as a work in progress that she hasn't worked on her opening statement until this past weekend. I don't believe that. I think if that's the case, then she's just lying to the court. But if that's not, if it's not the case, and she didn't mean to mislead the court just now, then she could have and should have shared those PowerPoints. As to the photographs, those also could have been shared with prior to opening. If there's no one's suggesting they're not admissible at trial. If they're admissible, she can admit them at trial. But to show them to the jury now is part of her opening that violates this court's order that we were supposed to share our exhibits for opening prior to trial, which she did not do. So I think they should be excluded from the opening. And if she wants to introduce them later as evidence during the course of the case, then so be it. But I think there is good grounds for this court to, and Your Honor got upset because these issues could have been handled. They didn't have to wait until now. This is wasting time while the jury's waiting. Your Honor's right. And it's not our fault. It's her fault for not doing what the court instructed. And as a result, the appropriate and reasonable remedy is to prevent her from sharing any of these slides with the jury that she did not share with defense counsel prior to today. Whether they're evidence or whether they're text is part of her opening.
All right, Mr. Matthews?
Yes, Your Honor. Good morning to the Honorable Court. I'd like to direct the state's attention to slide 15. In slide 15, the third bullet point, it references October 1st, 2020, in terms of that quote from the text message. In the indictment, Your Honor, if you look at Overt Act 102, that's where that particular quote comes from, Overt Act 102. In Overt Act 102, the date of that alleged text message was March 12th, 2020, not October 1st, 2020, as in the PowerPoint presentation, number one. Number two, the quote in the indictment is different from the quote in the PowerPoint. So that's two errors in slide 15 pertaining to Marquez Huey. And then you go to slide 16. Slide 16 is an overt act that is alleged in the indictment as Overt Act 123. In the state's opening presentation, the date they have is October 1, 2020. But in the indictment, that particular overt act is November 16, 2020. So that's the third error in the state's opening slide presentation. So those need to be corrected to mirror the indictment so that it's not misleading the jury and in fact giving wrong information to the jury judge. So I would ask that the state correct that, remove it, or correct it.
Anybody else? Yes, Mr. Short.
Your Honor, on behalf of Mr. Stillwell.
Speak up, please.
On behalf of Mr. Stillwell, slide number 47, it suggests that Mr. Stillwell is still committing crimes on behalf of the gang, even after being indicted on these charges. We began to discuss intrinsic acts and other unindicted allegations last week. But we did not get through it. And my understanding was that anything that you had not ruled upon, we were not supposed to reference or discuss in opening statements. So those are clear references to unindicted charges that we did not get a ruling on its admissibility yet. And I would ask that that just be taken out of the presentation and no mention be made of those.
Anybody else? Yes, Mr. Steele.
Thank you, sir. If you would look at also I'm looking at now, 48, 49, 53, 54, 55. That's your prerogative, that's within your zone, that's law.
Would the court allow Mr. Steele to repeat those slide numbers? Because what I think that he's referring to is something that I placed in here that the court said during its preliminary instructions to the jury. And it was regarding the court, as a matter of fact, it was the last thing that the court said. And all that I did was put on the slide, judge's law.
In terms of what slides are you talking about? Mr. Steele again?
I have 48, 49, 53, 54, 55.
So 49, 48 through 55?
Excluding, so 48, 49, and then skipping to 53, 54, and 55.
48 and 49. Your Honor, may I share via Zoom the slides that Mr. Steele?
I would, yes, please.
Thank you. And you said, Mr. Steele, you said 45?
Just share the presentation, please.
Yes, Your Honor. Okay, so Your Honor, I'm showing on the screen slide 48, which is the last thing that the court,
Take notes.
yes, Your Honor,
All right.
and.
49.
That was directly from what the court just stated.
All right. 50.
And 50,
It's not 50, sir, 53.
53, okay, let's skip down to 53. And 53 is what I expect the evidence is going to show. So I want to, in speaking to the jurors regarding the witnesses and the instructions that the court has given them, I'm going to say to them, some of them, as I've already alluded to, some of them may not be wanting to speak. Some of them, you're going to see evidence that some of them are afraid, some of them are embarrassed, some of them are intimidated, some of them don't remember, some of them don't want to remember. That's simply what the evidence will show. And Your Honor, what I'm asking that the jury does in listening to and considering the testimony of any such witnesses is, as the court has already instructed, which is just to use your common sense because you alone decide who you believe. We're asking you to listen carefully, take notes, and pay attention. So there's nothing in that slide 53 that is in any way infringing on or entering into a lane that does not belong to the state. We are entitled and allowed to show and to state to the jury what the evidence will show. The way that I have decided to represent it in writing makes it no less so.
Yeah, but it borders on argument at this point in time.
So I can change it because I do expect that the evidence will show that some of the witnesses are afraid, some of the witnesses are embarrassed. So I can take out.
Well, that's different. You might want to just redo it.
I can do that.
Any further objections, folks?
Yeah, sure. I went over to the state's table, Carson Matthews and Jeffery. I went over to the state's table and brought to their attention an error in slide 42, and I think it's incorrect.
All right.
Is that correct, Dave?
Here's
Not yet, but in a moment.
All right, here's what I'm going to do. Folks, this is exactly why I told you I wanted you to, and let me go ahead and just say this, Ms. Love, I told you to give them your PowerPoint presentation. This is why you give it to them, so that they can get errors and they can also figure out if there's something they object to. So this is what's caused this delay. Because at this point, like I told you, there's no secrets in the trial of this case. You all have gone through quite a long process. But this just highlights the concerns the court had in terms of just breaking up the presentation for our jurors. So what I'm going to do, ladies and gentlemen, I'm going to go ahead and call our jurors out. I'm going to go ahead and release them for lunch. I'm going to tell them they're going to be at lunch until 1:30. During the lunch hour, Ms. Love, I want you to play or the slides that you have that otherwise have not been shown. You need to show them to the defense counsel and make sure they're correct. In the absence of them being corrected, I'm going to exclude your presentation.
They have the presentation.
But it needs to be correct. I don't want, if I get another objection about an error, I'm going to exclude it for the purposes of the opening statement because you didn't follow my instructions. This is why I told everyone. They need to get and the defendants needed to give you their opening statements and the things they wish to use during their openings as well, because we're having interruptions and delay, and that's what I wanted to avoid for our jurors. That was the reasons I told you all to do that. So,
Your Honor, as far as any typographical errors.
I'm not worried about that. But I'm not worried about that. But the errors that Mr. Apt, Mr. Matthews, and Mr. Shaw have made are errors, and Ms. D. Williams need to be corrected. Okay?
Yes, Your Honor, I will, of course, do it for the record.
And, but everyone else needs to see it so they can be comfortable and make sure that you represented something that what you expect the evidence to show to be correct, okay?
Thank you, Judge. Will do. Your Honor, I also wanted to point out to the court that even if I misspoke, the court has already instructed the jury and will continue to instruct them that nothing I say is evidence, and if I misspeak or miswrite,
But that's not the point. I'm gonna tell them that, and I've told them that already, but that's not the point. The point is so that we can have a smooth and orderly presentation of evidence, okay? So, all right. Sergeant Ingram, can we go ahead and call for our jurors, please?
Your Honor, we'll look at also number 6-2.
You can go ahead and take up that during the recess, okay?
Yes, sir. Thank you.
All right. Yes. Okay, ladies and gentlemen, please be seated. All right, members of the jury, we apologize profusely for the delay, but I got some good news. I'm gonna send you lunch. How about that? The bad news is I'm not paying for it. So hopefully you all brought something or have made suitable plans consistent with the court's earlier suggestions to you. So what I'll do is at this point in time it's about 12:20, almost 12:25. I'm going to recess you until 1:45 to allow you to take comfort in taking a big long stretch and get yourself something to eat. I would advise you from doing this a while, don't eat too much carbohydrate laden food because you will fall asleep. And then I'll be looking at you and have to embarrass you. I don't want to do that. So I just ask you to take that nugget of consideration from somebody who's been doing this a while, all right? But remember my admonitions I told you. Remember when you go out, if you should decide to go out to eat lunch, remember you've got a time deadline you need to get back for, because we're going to try and call everybody out promptly around 1:45 or thereabouts and go ahead and get started. Leave your notepads in your basket if you decide to go out there, and remember all the admonitions that I've given you thus far, they apply to you and continue to apply to you. All right, so unless you have any other inquiry of me, ladies and gentlemen, I'm gonna bid you a good lunch and we'll see you back at 1:45, okay? All right, all rise for a jury. Not time yet. Please be see that our jury has left us. All right, so ladies and gentlemen, consistent with my earlier directions, go ahead and take a look at that, make those corrections, and I'll see everybody back for 1:45, and we'll go ahead and continue with opening statements at that point in time, okay? All right, we're in recess.
Okay, this is what I'm going to do. They're not coming back till 1:45 Central Standard Time. Okay. So what I'm going to do is I'm going to end this live, and then at 1:30 I'm going to come back. How does that sound? Anybody care? Anybody? Anybody? Okay, sweetie. I miss you, by the way. Just wondering what happened to you, too. Okay. Thank you, everybody, for being here. I will be back at 1:30. Thank you, Chantel. I was having a good day that day. Thank you very much. And what was that, 2 weeks ago? All right. See you guys at 1:30.